Back in January, I made a video. I think it was my first video of the year, actually, and it feels like yesterday, talking about a court case called Gonzalez versus Google that was scheduled to be heard by the United States Supreme Court. And depending how the court ruled, it had the possibility, and it's not hyperbolic, to completely reshape not just YouTube, but the entire internet as a whole with social media sites and user-generated content, and how that content could be recommended and consumed. If you'd like the full context for the case, I'll point you in the direction of the description, where I have a link to this video and you can get caught up. But now, almost 5 months later, the wheels of justice, they grind slowly. Isn't that what they say? I don't know. I'm not a lawyer, but the Supreme Court has issued a ruling. And it's interesting because I mentioned this at the end of the first video here, that when a piece of legislation is introduced or there's a pending court case, they could have disastrous ramifications for the internet. SOPA, PIPA, the net neutrality thing, those all come to mind. Rarely has it actually panned out to be as bad as anticipated. And maybe that's the wrong message to convey, because complacency isn't good either. It's always good to express concerns and not just hope that things will magically work themselves out. But in this case, the courts, not so much, they didn't rule in favor of Google. They simply said that the plaintiffs didn't really have much of a case here. And I've got to admit, I'm very surprised, in a good way, how authoritative this decision was, because I guess my expectations are always in the gutter when it comes to the government interfacing with the internet, because they're all old. And I've never had a grandparent who can properly navigate the web. And I know some people are going to be like, whoa, Jardon, having an opinion, supporting the outcome of a court case. And yeah, I suppose I'm a little biased on this matter because I would like to continue being able to make content that potentially new audience can discover. And I'd like other people to be afforded the same privilege. And I don't really want to see the internet return to a place where you have to navigate to every piece of content by knowing the IP address and typing it into your search bar, because sites can't recommend content for fear of being sued into oblivion. So anyway, the big highlight here is the Supreme Court said it didn't need to address whether Section 230 should be reinterpreted for Gonzalez versus Google, which is an overwhelming dismissal that basically says, yes, we know algorithmic recommendations exist, but they do not fall outside of the scope of Section 230 as it is right now, and YouTube can continue to operate as normal, and thus all other social media sites as well. Now, the timing of this is interesting. There may have been a little bit more detail given in their decision-making had this not come right on the heels of another case that they just ruled on that was very, very similar, but it was brought against Twitter instead of YouTube. The Twitter case was called Twitter versus Tamna. I don't know if I'm pronouncing that correctly, but again, very similar to Google versus Gonzalez in that it was about things that I'm not going to say verbally, but will highlight on the page that you can read. Otherwise, YouTube will end up suppressing this video. So the Twitter versus Tamna case was a unanimous ruling, which is astonishing to me because I feel like in this day and age, you could have a case about the color of the sky and there wouldn't be a unanimous ruling about that. So the opinion on that case stated there was insufficient evidence to establish that these defendants aided and abetted, the defendants again being Twitter in this case, not YouTube. And it continues, if aiding and abetting liability were taken too far, then ordinary merchants could become liable for any misuse of their goods and services, no matter how attenuated their relationship with the wrongdoer. That includes those who merely deliver mail or transmit emails, becoming liable. So you're a car manufacturer, you sell a car to someone, and then they go use it to rob a bank. Is the car manufacturer liable for those actions? In this case, there wasn't really any consideration to algorithmic recommendations. It was more focused on the fact that Twitter had hosted this kind of content at all in the first place. But the fact that they would then go and dismiss Gonzalez versus Google right on the heels of this without really even mentioning algorithmic recommendations, I actually find very interesting because I thought that Gonzalez versus Google actually did pose an interesting question, because does a piece of legislation written over 20 years ago still account for a technology that has emerged since then? Back in the 90s when 230 was written, we didn't have algorithmic content recommendations that we had to worry about. So could the court have decided that in its current writing, algorithmic recommendations wouldn't be covered, and therefore Google could be liable as a publisher? And would there be a need to amend Section 230 in order to more properly cover the internet and social media sites as it exists in the modern day? And the court overwhelmingly decided no. But again, very interestingly, not really focused on the algorithmic recommendation component. More so, it seems that slippery slope idea of holding a manufacturer, a host liable for bad actors kind of usurps any of the algorithmic recommendation stuff. And the ruling on Twitter continues. But the same could be said of cell phones, email, or the internet generally, yet we generally do not think that the internet or cell phone providers incur culpability merely for providing their services to the public. Nor do we think that such providers would normally be described as aiding and abetting, for example, illegal drugs brokered over cell phones. So I know I've mostly been reading off the ruling on Twitter, but that's because they go on to say regarding Gonzalez versus Google that the allegations are materially identical to those at issue in Twitter. So algorithmic recommendations or not, what takes priority over that is the fact that a web host cannot be considered aiding and abetting bad actors because they have equal ability to be able to upload their content to the site. So in the end, a pretty major ruling to allow for user-generated content to continue to exist in its current state online. Now, will this be the last existential threat faced by the internet? Absolutely not. There will be something else, whether it's legislation or a court case that's phrased in a different fashion, so it gets to be considered in a different way. There will be something that emerges in the future, inevitably. But for now, a bit of a sigh of relief, and we can continue making videos, and hopefully new people can discover them, and new people can go on to make careers making content. So that's it for now. Thanks for watching. See you next time.